Stuff. So you can mute yourself, and I will be introducing you here shortly. Welcome, my fellow warriors, to War Room number 13. I'm Mike Woodall, your host, and I'm excited to tell you our guest speaker has been quoted in the New York Times, the San Francisco Chronicle, the Washington Post, and many others. He's a former law clerk for the Justice William O. Douglas of the United States Supreme Court. Professor Ira Ellman. His paper, When Animus Matters and Sex Offense Underreporting Does Not, the Sex Offender Registry Regime, was a tide turner toward our united efforts to end the registry. I'll be sharing more about Professor Ellman later in his introduction. For now, let's acknowledge the people who work hard to make your time in the war room worthwhile. Co-host Clayton James handles the controls, so I can give my full attention to being your host. Clayton is also the timer, making sure we start and end on time. He will cue us with a green, yellow, and red signals to keep each participant within their time budget, so everyone has a chance to use their voice. Now I have a question for you. Have you heard this before? Injustice anywhere is a threat to justice everywhere. We are caught in an inescapable network of mutuality, tied in a single garment of destiny. Whatever affects one directly affects all indirectly. That's right. Those words are of Dr. King. Here's another thought from the good doctor. As my sufferings mounted, I soon realized that there are two ways in which I could respond to my situation: either to react with bitterness or seek to transform the suffering into a creative force. I decided to follow the latter course. To that end, we created the War Room to transform the suffering into a creative force. You see, nothing matters here in my world than to eliminate the suffering of millions caused by the registry, a virtual concentration camp, a real-world humiliation camp for those outside to openly mock and jeer with satisfying animus and rage. The War Room is a place for us, the suffering. We will have one special guest speaker at each meeting and additional speakers from our own ranks as we build our confidence, find our individual voices, and bring them together as one powerful voice, moving to the same beat of the drum. You see, our guest speakers come to listen to us too. They get to take some golden nuggets with them. And by listening to we who are most affected by the injustice, they will become more effective communicators. Our purpose: provide a safe room for those who are suffering humiliation, injustice, perpetual punishment, and the loss of dignity for themselves and their loved ones. Needless suffering caused by the registry laws in America. It's a room where we listen to others caught in the same as we struggle to free ourselves from our inescapable web. It's a room where we are all safe, knowing I am not alone. We can speak, we can listen, we can unite, find our voice, and the courage to stand and speak the world we see worth having, the one we deserve, into existence. Others have dared to speak a world worth having into existence. We find encouragement in their examples. August 28th, 1963, Dr. King speaks to the hushed crowd from the Lincoln Memorial. I have a dream, and tells us about the city of the beloved community, as he describes a table filled with people of all races. On September 12th, 1962, JFK stands in Rice Stadium and declares, "We're going to the moon."
Mike, you're muted.
Can you hear me now?
Yes.
At what point was I muted?
About 10 seconds before I said something.
Oh, okay. Well, I'm not starting all over. The point I'm making is others have dared to speak a world worth having into existence. It was Dr. King and John F. Kennedy. They found their voices and stood with courage and spoke something into existence that wasn't yet. Like great leaders before us, we must find our voices, develop the courage to stand, and speak our future possibility into existence. The future that isn't yet. Today, we are a divided people, splintered throughout the country in individual cocoons, feeling alone, isolated, hopeless, divided, and weak. But we are not alone. It just feels that way. When we include the collateral damages to our loved ones, there are millions and millions of us. We are not alone. We must begin to move to a shared drumbeat. We must unite, share, speak, listen, and be heard. We start with a safe environment where we can begin the process of becoming one voice of millions marching to the same drum. That, my fellow warriors, is why we have the War Room. Now let's get War Room number 13 kicked off with our first speaker. I'll be calling on those who have raised their hands and then unmute you. To raise your hand, simply go down to the reactions area at the bottom of your screen. And when you click reactions, there's going to be an icon that says raise hand. So I'm asking each of you to do exactly that. If you would like to use your voice, develop the courage, and stand and speak, or begin to speak the world we see worth having that is not in existence yet. We have our first hand raised. Linda Jordan, you are our first speaker.
Can you hear me? Can you hear me?
Yes.
Okay. Yeah, we lost your voice right as you said you were going to the moon. No one can hear you in space. That's the problem. I just wanted to let you know I'm still around. Very quickly, my husband's on the registry. We've been on the registry for about 5 years. I felt very isolated, depressed until we discovered you guys. And I've actually now also become involved in CAGE, another group, Citizens Against Entrapment in Washington State. So it sure feels good to have friends after being in the wilderness for 4 or 5 years. It feels good. And I think that's it. That's it.
All right,
Glad
thank
to
you.
be here.
It's I get emails from people all the time stating how this space, the War Room that we've created here, is providing a way for them not to feel isolated and for us to come together. So thank you, Linda, for sharing. Our next person with their hand raised is David Moore. David, what brings you to the War Room?
Yes, can you hear me okay?
I can hear you just fine. You could speak up a
Okay.
little more.
Oh, yes, I'm sorry. I've got these little Dollar Tree headphones. You'll have to excuse me, but I was just informed of this meeting by Mary Sue Molnar of TVRJ here in Texas. So it's real encouraging to know that we aren't alone. Not to self-promote or anything, but I did an interview with the lives on the registry YouTube side, and also it was produced by Narsal. So I'm real proud to have to express my voice and have an outlet for that. So it is much appreciated, Mr. Woodall.
Thank you, David Moore, and welcome to the War Room. We hope to have you back.
I will.
Our next speaker this evening is Anita Killen with the Florida Action Committee. Anita, can you tell us what brought you to the War Room and maybe something about your committee, but more importantly, why are you involved in this united effort?
Okay, can you hear me okay?
I hear you loud and clear.
Very good. Well, first of all, I want to thank you for having this opportunity for us to come together and hear this most important topic. I am the chair of the membership committee for Florida Action Committee. We're an advocacy group, and our mission is to educate the public, the media, and the legislators on the facts versus the myths about people who are forced to register. And we're also the Florida state affiliate for NARSAW. Without going into any background on our organization, I just want to share with you that on the second Thursday of every month, we have a what we call a new member orientation call. If anybody would like to call in and learn more about FAC and what we do and how we got started and all that, it's an open mic. Glad to answer your questions at that time. We also have a monthly meeting by phone, and it's on the first Thursday of the month at 8 p.m. Eastern Time. And our next call is on November 4th. And our guest is going to be Dr. Jill Levinson. She's going to talk to us about post-conviction stress disorder and the results of, or the analysis of a PTSD survey that she did earlier this year and the research that she's working on. So I encourage you to check out our website at floridaactioncommittee.org and join us with that. I personally am involved because of a family member. I have been working with we started the advocacy group around 2010. So we've been at this for some time. And there have been so many wonderful organizations that have come out of joining together. And I can just say that, you know, we're not alone. The organizations are not working alone either. It is just wonderful for us to be able to come together, opportunities like this, and strengthen our numbers and strengthen our voices.
Well, thank you, Anita, for joining us once again in the War Room. And you guys do tremendous work there in Florida. Thank you for your effort.
Thank you.
Our next speaker, if you don't have your hand raised, but I would really like to hear from Kim King. Kim, can you let us know what brings you to the War Room today?
Sorry, this is only my second Zoom call ever. Can you hear me?
Yes, Kim, and I apologize for that, but there's a reason why sometimes I call on people that have not raised their hand. And it's because we all in this united cause must find our voice and develop the courage to stand. And sometimes those moments in the elevator are the times where we need to find that courage and lose that fear and speak. So anyway, Kim, can you let us know why, what brought you to the War Room today?
Well, before we started, Vicki mentioned my name. I was on the phone with her yesterday. My fiance is on the registry, and he's been on the registry for 20 years for something that he actually did not do. and we're at our wits' end.
Yeah,
And so I started doing research online, and I found the war website, and I called Vicky, and she told me there's this whole network of people out there who are looking for solutions and making real changes, and some good things are happening. So I just want to see what it's about and see if we can get help.
yeah. Well, Kim, all of us in this room right now and thousands, a million others have walked through the door the first time and has had our initial experience of the shock and the injustice that you're going through. In this room and with the war organization, you're going to find kindred spirits to assist you with answering your questions, to give you some sort of relief for your soul, for your spirit, and to get the feeling that you are not alone. Because you're not alone, even though you feel isolated, you're not alone. So welcome, Kim, to the War Room, and just keep coming back.
Okay, thank you very much.
You're welcome, Kim. Next, I would like to hear from Rita Finley. Rita, could you please, I'm going to find you here. There you are. Hi, Rita.
Hello,
I've unmuted you.
thank you.
And let us know what brought you to the War Room today and how you are involved.
I have been involved with advocacy probably for 10 years. Excuse me. I am now on the board of Caution Click. We've been working together for many years for the same reason, to unite our voices for change. So I am here tonight to find a common bond, a common thread with other advocacy groups to move forward.
All right. Well, Rita, thank you so much for participating in the War Room, and we look forward to having you back.
Thank you.
Our next speaker this evening is Eric. Eric, what brought you to the War Room?
Well, I went to the NARSOL National Conference, my first conference this last weekend. And in fact, it's the first time I've left the state of Missouri in about 8 years. And I quickly found out that I was the only guy there on parole and the only guy there from Missouri. So, so I was quick to mention war and the War Room to a lot of folks, but 100% of the people there already knew of war and spoke highly of it. Several of them follow the site. But probably the most common thing I heard, as soon as I mentioned war, is people say, boy, I sure miss seeing Vicki Henry. So, and had nothing but complimentary things to say. So I know there's some kind of split between the approaches from the two groups, but just to let you know, Vicki, on a personal level, you seem to be loved and missed.
Oh, well, thank you, Eric. It's good to see you back in the War Room. Our next speaker for this meeting is Marty Wise. Marty, what brings you to the War Room?
Well, you know me, I always love to be involved, and I appreciate everything that you guys do. Hey, Ira, I know you're not a big football fan, but hey, Arizona State is really kicking some tail. Yeah, that's my alma mater, and I believe he was a professor there for a little while too. That's pretty awesome. Just want to say that this week has been absolutely amazing for me because I don't know how many of you guys know Amber Vlangas and Jason, who have the podcast Amplified Voices. I did an interview with them back in April, and it just got released this week. And I mean, I totally forgot what I said. I totally forgot how it, came off. And I felt so good afterwards. And I really, I mean, I feel like I just did I said the right things, the right places. And I'll be more than happy to post a link to it. So if anybody wants to listen to it, they can. But it's nice to know that we have a growing community, that we have a lot of supporters, and this is increasing and it will continue to increase. Thank you.
All right. Thank you for being a part of the War Room. Always
My pleasure.
Always love hearing from you, and your enthusiasm and your participation in the organization isn't missed at all.
Thank you.
Oh, and Marty, you
Yeah.
mentioned someone who was doing the podcast.
Yeah, Amber and Jason.
Yeah.
And looks like somebody got it in there before I could. Thank you, Mark.
Yeah, I believe Amber registered for the meeting tonight, and so hopefully we'll hear from her.
Oh my God, I'd love to hear from her.
Amber,
She's awesome.
If you're on one of these pages, send me a chat in a box, and I will get you on. Thank you, Marty.
No,
Our next speaker for War Room number 13 is Jim Zezzo. Please forgive me if I got your name wrong. Jim, what brought you to the War Room?
Hi, can you hear me?
Loud and clear.
Yeah, I started with Cure Sort, and is that the Wayne Bowers in here? That's like president of Cure Sort, Wayne Bowers. He's a founder or president with Cure Sort. I'd like to hear from him.
Yes, so he's
He
on deck.
Yeah, I'd like to hear from him. I've never seen him before. I've been with Cure Sort for a while there. I'd like to hear from him.
Well, Jim, thank you for being a part of the War Room. I look forward to seeing you again. And next on deck is Wayne Bowers. Wayne, what brought you to the War Room? And maybe you can answer a couple of Jim's.
I was just trying to hide, and Jim found me, didn't he?
He called you out.
And Jim's been one of our members with Cure Sort a long time, and I appreciate his involvement. I started with Cure Sort in 1993. It was founded as an issue chapter with National Cure, Charlie Sullivan's organization, in 1990 by a man named Lauren Perry. If you know Kay Perry in Michigan, the director of Michigan Cure, he is her brother. He passed away right after I moved to Michigan to work with them in 1996. And so I've just taken it on since. We don't emphasize as much as war about the registry. Our main thrust is promoting therapy for those who have some type of sexual dysfunction, for those that need it. But naturally, the letters that I get, many are asking about the registry, of course. Those still in prison, of course, are scared about it, have heard about it. So I definitely am involved and stay in touch with Vicki and all of you and many others. Having been in this as long as I have, it's been my pleasure to network with just a lot of people. So I really respect the programs that you all are putting together on this, and I try to get on as many as I can. So congratulations on this. And Vicki, all the good work that you do.
Thank you, Wayne. Always appreciate having you. Our next speaker is going to be someone who does not have their hand raised, but I'm dying to hear from her, Barbara McClellan. Barbara, what brings you to the war room this evening?
Well, good evening, everyone. I guess I'm being heard. I think I've hit the right buttons. Story
Yes.
of my life, hitting the
You're
right
coming
buttons.
in live and in person.
I attended the very first RSOL conference in Boston. That's where I met my good friend Rita Finley. We were hidden away in a little private room that belonged to a law firm. We had about 30 people, and then we connected electronically with Mary Sue in Texas, with Texas Voices. But we've all had a beginning. Wayne, you've got me beaten because you started earlier. This was, I believe, in 08 or 09. So not to bore, I'm an educator. I believe that the registry is a failed social experiment, if you would. It does far more harm than good, and that's my advocacy work. There are so many, including Vicki, that I've had the honor of knowing and working with along the way. I've attended 7, I think, RSOL, now NA RSOL conferences. I am an affiliate member of ATSA, and I've gone to 6 ATSA international conferences. They're wonderful, and it's only like $70 a year to become an affiliate member, and I think that's a value as well. Vicki, I especially love you. I owe you an email, and I'll be sending it to you later tonight with an initiative we're working on, trying to educate the public. So tonight's study with Dr. Ellman, it just fits perfectly with what we're wanting to do. As an educator, we need to educate the public. We're living in a time of misinformation more than ever before, and we are the victims of misinformation. So I just love you all, and I'm glad to be with everyone.
Yeah, Barbara, we really appreciate your continued support and your ability just to hang in there for us. You know, whenever you did that first one, there was a great sense of fear.
That's right.
Yeah, I remember in 2011 at the NARSOL conference where I spoke and ATSA was there. There was a sense of fear, and people were on guard and had extra precautions and things. So we've come a long way.
We have the information for our registration was sent only through the mail. We've signed up, but then everything after that was sent with individual correspondence because we were fearful of demonstrations and et cetera, et cetera. So you're right, we have come a long way.
Yeah.
Thanks to all of you.
Thanks for being here. And I just want to take a moment. We've really come a long way. And if it wasn't for the work of people like Ira Ellman, we wouldn't be half of this way down this journey. And I'm just going to just say that. And we appreciate Ira Ellman in our cause. Our next speaker is Mark Legato. Mark, what brought you to the war room? Mark, you'll have to click your unmute button.
Can you hear me?
I can hear you now.
Okay, thank you. Yeah, I'm from New Jersey, and I've been a Tier 1 registrant now since 2013. And I've been reclaiming my life and looking to advocate for changes to the registry for social justice. And every time I reach out to different groups, I find that there's really nothing going on in New Jersey, or they have one person in New Jersey who just says, talk to your legislature. And so I decided that it's time for me to step up to the plate and for me to start to advocate for legislative changes as opposed to impact litigation, which is what everyone's trying to do, it seems. And I want to start to network with people, gather information, and start to talk to my legislators about advocating for change, similar to California, the model penal code revisions that they're proposing. certain other things that I'm seeing popping up around the country and tie it all together. And so I'm really looking to network and gather that information to make the legislative changes necessary to the registry.
All right, Mark, well, welcome to the War Room, and you're in the right spot for all the resources that you need to find the courage to stand. It takes a lot, Mark, doesn't it?
Yeah, it does, but I'm ready to do it.
And just finding your voice, developing the courage to stand and be able to speak out is hard to do. The fear is deep.
Yeah, it is, but you just have to you have to do it. You have to walk through the door, right? And
That's
90%
right.
of the stuff we worry about doesn't happen. You just got to get up one more time, then you get knocked down.
All right, we'll see you at the next meeting.
All right, thank you.
See you, Mark. So we are going to cut short our typical speakers from our audience because I'd like to jump right straight to Ira Ellman and get him into his program so that I know we're going to have a bunch of questions for him. So we'll end his presentation with a Q&A period. Ira Ellman is currently Distinguished Affiliated Scholar at the Center of the Study of Law and Society at the University of California, Berkeley. He's retired from Arizona State University, where he was a chaired professor of law and affiliate professor in the Department of Psychology. Before entering academy in 1978, Professor Ellman was a law clerk for Justice William O. Douglas of the United States Supreme Court, a legislative aide to Senator Adlai Stevenson III, a consultant to the California legislature, and an attorney at a major San Francisco law firm. Professor Ellman spent much of his academic career doing research with psychologists on issues in family law, but has in recent years focused on sexual offense laws, and especially the registry. He has written amicus briefs on behalf of a group of 18 law and social science scholars in 9 sexual offense cases, including 3 in the United States Supreme Court, as well as others in California, Pennsylvania, Oregon Supreme Courts. He serves on the informal steering committee of the Sex Offense Litigation and Policy Resource Center at Mitchell Hamline School of Law. Let's everyone give Ira Ellman a big War Room welcome. There you go, Ira. Unmute yourself.
I am unmuted. Thank you, Mike, that generous and warm welcome. I'm glad to be able to contribute something to this effort. I actually had a strange moment of deja vu, and one of the earlier speakers, Barbara, I don't recall her last name, said she was at this very early meeting many years ago in a small room. And actually, I think that I remember reading, I know that I read, I think it was about that meeting, a small piece in the New York Times, not on page 1, many pages in, about this strange gathering of people who were objecting or concerned about sex offender laws. And it was kind of a curiosity piece, kind of a man bites dog piece that the Times had at the time. And I remember reading that and thinking, this seemed like an interesting question, but I continued working in the areas that I had always worked in and did for, more than a decade thereafter. So it was really late in my life that I came to this issue and these questions. And I did that like so many people, when people who mattered to me got embroiled in this system. And so actually it's been the main thing I've been doing since I retired and for some time before. I have a talk that I prepared tonight because Vicki asked me if I would talk about this paper that I recently wrote, which has not yet been published. It's scheduled to appear in November in the Law Journal at the University of Pennsylvania. And so I agreed to do that. And I'm going to sort of share the screen and bring that up while I continue talking here so you can see not the paper itself, but a PowerPoint that, oh, wait a second. Let's see. Oh, I see. Okay, now I got it. Okay, so people can see the screen, I assume. Can folks see my screen?
Yes, everything is looking good.
Yeah, okay.
I had my
Okay,
stuff muted.
so this paper is a law paper, and it's going to have a lot of stuff in it, the paper itself, that I think it would not be so interesting for many people in this group. But I think there's some important points to make, and I've tried to put together a presentation that would be accessible for people here. And so, and I know we do have some lawyers here too. So let me do that. Okay. Oh, I've got a thing across the top of my screen that I don't want there. It's a little bar, control bar, I guess, from Zoom that I wish was, I can move it. Okay. Okay, so I'm going to start by giving a little background because Vicki asked me to talk a little bit about an earlier paper that I wrote that did get a lot of attention that was connected to Smith v. Doe, a case that probably, I'm sure at least some, maybe everyone here has heard of. That was the infamous case in which the Supreme Court in 2003 upheld the Alaska registry. It was being challenged by a fellow whose sexual offense had been committed before Alaska adopted the registry and its public website. And he was challenging their applying the registry to him, saying that, this was in effect with an ex post facto punishment that was being applied to him. Ex post facto is this legal phrase that stands for the idea that someone's being punished by a law that wasn't enacted until after they did what they did. So it's a kind of retroactive reaching back. And that's forbidden by the Constitution. You can't have ex post facto criminal prosecutions. And that was the heart of his challenge. And he lost in the Supreme Court. And, oh no, let's see if I can. He lost in the Supreme Court. But in a memorable phrase, the court said, well, the sex offense reoffense rate is frightening and high. And they referred to a Justice Department report saying it was as high as 80% of the people who'd ever committed the sexual offense, after they'd been arrested and punished, they went on and did it again. And so they cited this Justice Department report. And what we did in this article is point out that report that they cited had no data. It did claim this 80% figure, but it didn't offer any any data for it. Instead, it cited this article in Psychology Today. Some of you may know that magazine. It's a popular magazine. It's not a professional journal. And the Psych Today article was written by a therapist who claimed that his program reduced sexual offending so that was his great contribution, to develop a therapeutic program that he wanted to tell folks about that reduced the likelihood of sexual offending, which he said, for those who didn't take his program, was as high as 80%. So this article was a kind of advertisement, in effect, by this guy. But the court cites the Justice Department study, which had no data, but had, if you went back, actually was the statement was based on this Psych Today article. Over 100 cases in various courts around the country in subsequent years then cited this phrase, the frightening and high phrase, in a whole series of cases in which they rejected claims challenging the registry, and that became a kind of mantra for that position, that all these things are justified because the reoffense rate was frightening and high. Now that was clearly a mistake. I mean, if the court had actually, there wasn't very much, there was some data then. There was definitely some data. There's a lot more data since. All of it, of course, shows that that statement was wrong. The fellow who wrote the article in Psychology Today that was cited has actually since recanted, said, oh, I didn't mean that, anybody to take that seriously. And so it's something of a scandal, but it's still, the case still sits there, and it's an important case, and it's worth asking, why did this mistake matter so much? And the answer is because the high rates were offered to justify the registry as a civil regulation meant to advance public safety. And why did it require that justification? Why not just call it punishment? I mean, you can punish people for who've been convicted of a sex offense. So why doesn't the state just say, well, it's punishing them? And the answer, you don't need any justification to punish people who've been duly convicted for having committed some bad act. The answer is that punishment has other requirements that the state has to meet before it can be put on anybody, and the registry fails those other requirements. There's the ex post facto requirement that was raised by the fellow in the Alaska case. So you can't lengthen somebody's sentence because after they've been convicted, you've gone back and thought, well, we should have really had a tougher sentence for that crime. So we're going to now retroactively lengthen his sentence. That would be a classic kind of ex post facto problem. And that's different from, somebody gets out and you say, well, you can't own a gun. That's a civil regulation, and it has a public safety rationale, and it's not limited by the ex post facto clause. But anyway, so you see punishment has a number of other requirements. One's ex post facto. One is that a state can't add to the punishment imposed by another state. Texas, if somebody moves to Texas from New York and Texas decides, New York didn't punish you enough for that crime that you committed, and they let you out and you move to Texas, but we want to put you back in jail because we have a tougher law here. Well, obviously they couldn't do that. And so if the registry was punishment, Texas also couldn't put them on the registry. Or no state could put anybody on the registry for having committed a federal offense, like a federal CP offense, because that would be adding to the punishment that that had already been meted out to that person in the federal system. So, and finally, you can't punish people without some kind of due process. You can't just pass a statute that identifies people that you say we want to punish these people. Here it is. So these are all the reasons why it was important for Alaska to be able to win in that challenge in the Supreme Court, to come up with some explanation why this is a civil regulation, and it's a civil regulation that is also only allowed unless it has some purpose. You need some kind of rationale for a civil regulation, and that solves all these problems with the punishment claim. So can we say, back to Alaska, well, you calling it a civil regulation, but really it isn't. It's really punishment. And in fact, since the time of Smith v. Doe's decision, some courts have reached that conclusion, that it really is punishment. Other courts have not. Now, it's hard for courts to do that, federal courts to do that applying the federal Constitution, although one has, and we can get back to that later because it's a very important case. But a lot of state courts have held that on the basis of their state constitution. The key question in all these cases is the registry so punitive, either in purpose or effect, as to negate the state's claim that it's civil. And if a law burdens people, does not advance any permissible public policy, then its purpose has to be punishment because it has no other public purpose. And a civil measure that burdens people has to have a permissible policy. So of course, the policy purpose offered to explain the registry is public safety. And so the paper that I've just written argues that the registry regime cannot be justified as a civil public safety measure because the data shows it does not advance public safety. And I want to pause here. I put regime in boldface because what I think is really important is to see the whole system with all of its parts, not just the registry that requires people to sign up and puts the majority of them on a public website. In some states, everybody, in some states, a smaller percentage, but most of them end up on a public website. That's a sort of the core registry. But everybody who's participating in this war room meeting certainly is aware of all the other things, all the other rules that are generated that apply to people who are on the registry or people who've committed a sexual offense. And, things like a stamp on your passport, a rule that if you have a relative in another country who wants to come, your wife, your children, you want to sponsor their coming to the United States, you can't do that just because you're on the registry. And then all the residency restrictions, internet restrictions, everyone, I don't need to go over them all here because everybody in this war room meeting is going to be familiar and some very closely familiar with all of these things. I do summarize them in the paper, and it's really quite daunting when you go over the several pages listing all the different things. So what I'm arguing then is that the registry regime is actually an impermissible one. It's punishment arising, punishment arising from animus toward those convicted of a sexual offense. That's its actual purpose because it cannot be justified as a civil public safety measure. Okay, now an animus claim is a tough claim to make because normally legislature courts do not look at why legislators enacted something. The legislative motivation is not usually relevant in judging whether or not a law violates the Constitution. There are just 4 cases the Supreme Court's decided that have done that. 2 of them, Moreno and City of Claiborne, are pretty old. They're back from the era of the Warren Court, the very liberal, famously liberal Warren Court. But there are 2 more recent cases that have done that, Romer and Windsor. Romer in 1996, Windsor in 2013. And Romer is the key case. And the thing to understand about Romer, because it involved gay people, is that this case was decided long before the 2003 case, Lawrence, that said states could not make it a crime to engage in homosexual sodomy, or the 2015 case, Obergefell, which made marriage a constitutional right that applied to gay couples as heterosexual couples. So those cases came much later. And so here Romer back in 1996 is striking down a state constitutional provision in Colorado that said cities, counties, the state university, none of the various subdivisions of the state may adopt any rule that said you cannot discriminate against gay people. And there were a lot of locales in Colorado, including Denver and a lot of other places that had anti-discrimination laws that applied to gay people. The University of Colorado did. They were all thrown out when Colorado adopted this state constitutional amendment. And so one could have said, well, gee, this is a bad amendment because it discriminates against gay people, but there wasn't any rule that barred discrimination against gay people. That, arguably has shifted since the decisions that I mentioned, Lawrence and Obergefell, but those long after. Romer is a 1996 decision. And so what the court said, in explaining Romer, they first went over all the different laws and ordinances and regulations that were revoked by this new constitutional provision, threw them all out. And the court said, it's important. One has to distinguish between laws that serve a broad public purpose that justifies the incidental disadvantages that the law imposes on certain persons, as compared to laws that, and these are the court's words, have the peculiar property of imposing a broad and undifferentiated disability on a single named group. Now, it doesn't take a lot of imagination to think about how the Romer holding could apply to the registry. I mean, let's think about it. Laws imposing a broad and undifferentiated disability on a single named group, this is the court's words, raise the inevitable inference that the disadvantages imposed is born of animosity toward the class of persons affected. Continuing on the court's logic, I'm not quoting, but it's what the gist of what they said, the more sweeping the burdens imposed and the narrower the targeted group, the more closely one should examine the state's asserted purpose for the law. If you have a law that imposes sweeping burdens, all sorts of different things, it's hard to find a single policy purpose that could explain all these different burdens that are being imposed. And when they're being imposed on a very narrow group, it really heightens the inference that the real reason for it is animosity. Does that sound like the registry regime? I think it doesn't take much imagination to see that. The incredible array of federal, state, local laws affecting registrants is unprecedented. There's no similar regime imposed on any other group of law-abiding former felons who have already served their sentence, often many years ago. So a court applying Romer therefore would have to ask, does the registry regime's purported purpose hold up? That purported purpose being public safety, or is animus the only explanation for the law? So the paper then goes on to answer this question: does the registry regime advance public safety? And you know, in the years since the original Smith v. Doe was decided, there have been many, many studies, and they keep piling up. And I put them in three groups. All three groups show that the registry regime does not and really could not advance public safety. The first group is studies that show that public notification, the website, and residency and presence restrictions don't reduce sexual offending. And there's all these studies that compare offense rates with and without the website, with and without residency or presence restrictions. There's and they all find there's no difference. It doesn't reduce sexual offending. And there's a wonderful Minnesota study that went back and looked at the cases in which people did reoffend and asked, when it's over a 10, 15-year period, asked, well, would any of these reoffenses have been prevented if we'd had a residency restriction, which Minnesota did not and still does not have? And the study done by the Minnesota government concluded, no, not a single one of them would have been prevented by a residency restriction. So that's one group of cases. A second group, studies that show why the registry regime can possibly be effective at lowering sexual offense rates. That's because 95% of those arrested for sexual offenses are first offenders. So the registry regime couldn't have applied to them. They're not on any website. There's no other rule of the registry regime. All the great massive rules I'm just referring to, none of them would apply to such a person. And those people account for 95% in any given year, 95% of those arrested for a sexual offense. Third group of studies is that show why most sexual offenses are committed by first offenders. And that is, of course, and these are probably the studies many of you are most familiar with, relatively few sexual offenders do it again after release. One of my, I think, studies of this, because it follows people for 9 years, and it's important. 92.6% do not commit another sexual offense. 7.4% do. This is over 9 years. And you could compare that, for example, to the proportion of people who've never committed a sexual offense but were in prison for robbery, and ask, well, what percentage of those commit a sexual offense after being released? And this study found 3.4%. So yeah, sure, sexual offenses are a bit higher, but I mean, there's an awful lot more people who've committed in prison who commit crimes other than sexual crimes. And if you look at sexual crimes committed by people who've been released from prison, 84% of all the offenses committed by such people are committed by people who had no prior history of sexual offending. So you put all these studies together, and the conclusion is that the registry regime is an example of a rather famous error called the streetlight mistake. It's named, the error is named after the apocryphal story of the fellow who sees somebody searching on the ground under a streetlight, goes up to him and asks if he could help. What's he looking for? He's looking for his car keys. And he's a drunk. And the guy's having a lot of trouble finding anything. And so this guy tries to help him for a while. He doesn't see any car keys there. And he finally asks the drunk, he said, well, is this where you lost the car keys? And the drunk says, no, I didn't. I lost them in the park, but the light is much better here. So you're looking for the car keys where there's light. It's the same thing. The easiest people to find are the people who we've put on the registry. So we're going to look for them, even though in fact, that's not where the offending is. So the paper makes a couple of other points that are important, but I'm just going to mention them quickly here. And I'm not going to go into them in any detail. People interested, we could more in the Q&A period. But everybody knows the first point: the registry regime fails to distinguish sensibly among those with sexual convictions, which also undermines the safety rationale, because it ends up applying to lots and lots of people who are very, very low, even lower than the averages probability of sexual offending. Some rules just lump all registrants together. Tiering rules attempt to tier, but they often use criteria that are unrelated to actual reoffense probability. But the biggest thing is that so many of these rules and so many of the registry laws, almost all of them, really don't pay enough attention to the tremendous decline over time since release from prison in the likelihood that someone will commit a sexual offense. People who, even if they start out with some non-trivial chance of reoffending, if they haven't reoffended after 5, 10 years, the chance of their reoffending then becomes very, very small. And that's ignored by all these laws. But then why are we applying all these rules to people we know are almost very unlikely to reoffend? And finally, and this is where the other part of the title of the paper comes in, and I won't do this in detail, the underreporting of sexual offenses doesn't affect the validity of any of these studies that show that the registry regime is not effective. The underreporting, I mean, sexual offenses are underreported. Actually, all violent crimes are underreported. But it doesn't matter to the point that's being made here. It does not alter the fact that registrants commit very few of all the sexual offenses committed, whether they're reported or not. It does not alter the fact that, that the public notification and residency rules have no effect. So that's that. Here's you know, a kind of concluding sentence. You can read it yourself. I don't need to read it to you, but this is sort of, I think, the summary of what the paper says. So that's what I have, and I'm happy to discuss anything I've said further, respond to questions. There we are, Mike.
Well, thank you, Ira. That was a brilliant presentation. I learned more about Smith versus Doe, 2003, and it's amazing because this is coming just at the right moment. Janice from California, Janice Bellucci, has put together a vigil on the steps of the Supreme Court on March 3rd, 2023. And that is the cause that we are all uniting around and going to make happen. That is the 20th anniversary of the decision that you were shared with us today. Janice wants to go to the steps and let the Supreme Court know they got it wrong. And that's what we are committed as the registered nation to make happen. So thank you for this presentation. Let's everyone give Ira a big round of applause for this presentation. Thank you, Ira. We're going to open this up for questions and answers. Again, I'd like to explain that if you would like to ask Ira a question, go to the box down below, the icon that says reactions. And when you click that, you're going to see another one that says raise hand. It's going to be the biggest, the first one on the bottom, usually. So I'm going to be opening this up for questions here. As soon as I see the hands, there they are. Oh, they're coming up all over the place. Looky there. David Moore, you are the first. Do you have something for Ira?
Yes, hi, Ira. First of all, thank you for your bravery and courage. I wish you would move to Texas.
You
I'm
know, I'm
a,
having a little trouble hearing you, David. I wonder if you can speak
Okay.
a little more loudly.
Okay. Yeah,
That's
I just
better.
want to thank you for your,
Good.
can you hear me better now? I
Yes.
just want to thank you for your bravery and courage. And for an example, I'm registered in Texas, and I went to a mental hospital for being depressed, and my parole officer and my counselor both approved it. And then 5 days after I got out of the hospital, I was arrested for not reporting to counseling, even though both of them knew that I was in the hospital, and they revoked my parole, and I spent 4 years and 7 months in prison in TDC.
Right. And do you have a question for Professor Ellman?
Yes, I just, well, not really so much a question, but I did want to thank you for your advocacy. It's, please don't think it's not ever taken for granted. And that's about it.
All right. Thank you, David.
Thank you.
Our next person on deck is Marty Mizzle. You're going to, I butchered your name. Marty, you're on.
Actually, it's Al Mizell. My wife is watching.
Oh, Mary.
The question for Ira is, are the statistics the same for those who reoffend out of the general sex offender population as those who have had therapy?
There's some indication that therapy reduces offending. There's some. And I know of a few studies that find that. I think the problem, though, is that there are so many barriers to rehabilitation that are created by the registry regime that it really makes it difficult for a lot of people to reestablish social connections, to get employment, to find place to live. And people who are put in that position often end up committing a crime, maybe not a sexual crime, but some crime. I mean, it's just very difficult. So I think, there is some basis. Are some studies that find therapy would help. But what I always feel is that therapy would be a lot more effective if all these barriers to rehabilitation weren't put in front of the people who had taken the therapy.
Thank you.
Thank you. That was a good question. Our next person is Gus Castillo. Gus, you're on.
Yes, thank you. My question is, I keep hearing differences of opinions in reference to the probability of the Supreme Court retaking this issue. I know that it's a very low percentage of cases that they take, but apparently some people, I don't know how, have gotten some sort of wind as to the mindset of the Supreme Court. And I'm wondering if you're aware of any indications as to whether the Supreme Court is actively avoiding this.
This question makes me sad. And the reason that it makes me sad is because there was a point at which I really was very hopeful about that. And the reason I was hopeful has to do with the fact that the author of both the Romer case and the later case that I mentioned, Windsor, the two recent cases that really are responsible for this animus argument that one can make, both of those cases were written by Justice Kennedy, who of course is no longer on the court and was replaced. His seat was replaced by one of the Trump appointees. Justice Kennedy was an interesting guy. He was appointed, I think, originally by the first Bush. He certainly was a Republican appointee. I don't remember now for sure which president it was. He was on the court a long time. He was hardly a left-wing justice, but he was a very decent man. And one of the things he really did care about was how people were treated in prison. So he wrote the famous, really the most important cases the Supreme Court wrote. They told the state of California, you've got to spend twice as much money on your prisons or get rid of half the prisoners, because you're treating them so badly that it violates the prohibition against cruel and unusual punishment. And really an incredible decision. But one of the things he was also concerned about, it became clear, the court decided a case the year before he retired about internet restrictions, a case that said that a local law that just barred anybody who was on the registry from being on any kind of social media, and had a very broad definition of social media. So, if you signed up, you couldn't make a comment on the New York Times website that you were on social media. I mean, it was ridiculous law. And most of the court threw it out on First Amendment grounds, and he joined that opinion. In fact, he wrote it, but he made a comment in this that just sort of invited a challenge to come back to this, because he said it was a by the way comment, but he said, we're not in this case going back to examine all the troublesome restrictions put on people who are no longer in the criminal justice system. In other words, people have been released from custody, are not on parole, etc. And he made that comment, and that really thrilled me, because it really made me think. And you got to realize, Justice Kennedy also wrote Smith v. Doe. So this is the man who wrote that case telling us, maybe people took what I said too broadly. And the hope that I had was really was confirmed in it the following year. Maybe I'm going on too long, but this is a kind of interesting story, I think, for those who care about the question that's just been asked. The ACLU in Michigan had a successful case challenging the Michigan registry. And the state of Michigan sought to get the Supreme Court to review that decision so that they would reverse it. And the question was whether the court would take that case. And a lot of us were getting sort of prepared to help defend that decision in the event that the court took it. And a key thing in that case was whether the federal government, which at that point was, under Republican, well, I won't go on to that, but in any event, the federal government was invited to, by the court, tell us what you think about this. And it was up in the air what they were going to say. Well, they ended up, after thinking, I think, about what Justice Kennedy said, telling the court, don't hear this case. Don't hear this case. And the court didn't. And so that decision from the Sixth Circuit Federal Court of Appeals, it still stands. It's a real beacon that others have referred to and relied upon. But it would have been nicer had it been taken and affirmed by the Supreme Court, which I think might actually have happened. But that moment, that hopeful moment has passed, I think. Justice Kennedy's gone. There have been two other appointees. I wouldn't say it's totally hopeless. I would not say, and I could go on further, I'm going to stop myself and explain why, but it's certainly not hopeful. And so what I, and I think some others have suggested, is that if you want to challenge things, in a lot of states, you would have more luck in state courts and looking at the state constitution. I think that's true in California. I think that's true in some other states. Obviously, it's not true everywhere. But I was heartened, for example, by the Louisiana Supreme Court rendering an opinion not too long ago, throwing out the state law that required people's driver's license, if they were registrants, to carry a statement that they were registrants. That's a decision of the Louisiana Supreme Court. So, you know, if that happens there, maybe it can happen in lots of places. At least that's what I'd like to hope.
All right, Gus, thank you so much for that question. I have a question for you, Ira. And it has to do with vigilantes using the registry as a hit list. I know that I've been on the registry for 20 years. 20 years of my picture, my poster being put on telephone poles throughout my neighborhood. My tires, all 4 tires on my vehicles being slashed at least once a year. BB guns through my garage door, rocks through my windows. I was dealing with some mysterious person for 3 years who was putting bricks in my gutter, weighing it down. Hopefully it would fall. Is there any studies or work being done on the registry actually being a hit list for vigilantes?
Yeah, I mean, this is a horrible phenomenon, and obviously you're not the only person who's experienced things like this. You know, I mean, when I was still teaching at ASU, there was a new professor in the criminal justice school who just made this terrible mistake, wanted to explain to students about the sex offender registry, and, you know, started putting up profiles in class of people who were on the registry to show them how it worked. And one of those people then ended up being harassed. And I remember trying to talk to that professor. I hadn't had very much luck reaching her about, you know, she really needed to make some statement to the class about that. I think she regretted what she'd done, but couldn't put the toothpaste back in the tube.
Yeah.
And so, yeah, this does happen. You know, there's all of those things that they're doing to you are, of course, either criminal acts. I mean, the registry does not make you not protected by criminal laws that penalize people for hurting you. I mean, so that, you know, you could, if you knew who they were, you could report them. And I do know somebody years ago who came home to find people there prepared to attack him physically, and he did succeed. This is in Southern California, getting the police to arrest these people.
Mm-hmm.
So, I mean, there's that. You can also, if you know who they are, bring a civil suit, but against them for the damage to your home. You know, some of your examples involve that, or to your car or whatever. I mean, so there are remedies, but, you know, the thing is, why does this happen? It's a reason why. It's just one reason why the website is such a bad idea.
So you're not aware of any study that's been done, any PhD or professor or someone has taken on that angle?
Not well. What is it you'd want to know? There have certainly been studies that have been done of registrants, you know, interviewing registrants about experiences, and certainly there are some that report experiences like the one you had. I mean, so there are studies like that. It's very hard. I don't know of any. I mean, the fact that I don't know of it doesn't mean it doesn't exist. But I don't know of any studies that tried to systematically count, so we could say, you know, this has happened to 27.4% of all registrants or something like that. I mean, it'd be interesting, actually, I think, to to have studies of the people who do these things.
Right.
To see if there's some common thread there that explains, because most people don't. You know, they may say, I don't want to have anything to do with you. They may, you know,
Yeah.
and they may try to keep you from joining their club or something, but most people don't try to attack you. So, I mean, that's a criminal class.
Right. And you know, all cops aren't bad. There are a few. I know that when the last time my tires were slashed, there was a handprint. You can see the full hand palm on the fender where the person was leaned up against it as he was slashing. And it was so vivid. I took a picture of it and the cops looked at it and said, well, we can't bring in forensics on this. So it was just written off. So anyway, I think it'd be an interesting study for someone to do. And I think also when cops pull over people, they log things down in categories. The crimes go in categories. And I think it would be a nice category if they would include all offenses against people on the registry. So anyway, I'm going to move on to our next person. Thanks for hearing me on that. Vicki Henry, you have your hand up.
And so I'm unmuted, correct?
Yes, you are.
Okay. All right. A couple of real quick things because I can see several hands up. But we did and Mike Teeter's on here and he participated with John Grund. And they did a survey of all 50 states to see how many states had the disclaimer on their sites that talked about harming a registrant or harassing a registrant and their families. And some of the states now have where you have to agree to that. And when you do that, of course, they have your like footprint, so to speak. And there was only, I think, 12 states or something like that, maybe 19, that didn't have the disclaimer. Some said, oh, yeah, it's a good idea, you know, that kind of thing. Of course, Florida said, no thanks. But anyway, so that's one thing. And as far as taking pictures, you guys are all tired of that, going in and having your picture taken. And of course, we tell people when you do go in, make sure you're clean cut and all of that. But some of you have heard the Dennis Hogan story. Dennis got tired of the same thing. So he went to, and he's in DC, and he went to register and he took his camera and he took a picture of the registry clerk. And he made copies of it and he posted it all around the office, that whole facility. And she went berserk. And she said, you got to take that down. He said, nope, no, I don't. I can keep it up. So anyway, she got so frazzled, she got a job in another department in the building and filed lawsuit against Dennis. And the ACLU of DC represented him. And that was the first peaceful protest that we had done, along with Dennis and his people and Derek Loeb and us. And so he won. But, you know, and we hear all kinds of stories about things that people do to registrants. So either they need to make some changes or we need to ask for it to be a hate crime. That's my opinion. That's all.
Do you have anything to add to that, Ira?
I'm sorry?
Do you have anything to add to that?
No. I mean, I said the disclaimer on the website, you know, California has it. It's, you know, it's certainly, I'm glad they have it. I'm not sure how much it deters people.
Yeah.
All right. Thank you, Vicki.
Mm-hmm.
Ron Terry, you have a question for Ira?
Yeah. Can you hear me?
I can hear you loud and clear.
Yeah, Ira, this is the first time I've been on the call, and Mike's a friend of mine. And my question is my son is on the register now, and he was convicted. They found that he looked at 3 videos of child pornography over an 18-month period. So it wasn't daily. And they didn't find any on his computer, or that he had bought any or made any or distributed any. And he was served 48 months, and now he's on the registry for 10 years. And I guess what it seems so unfair is he never touched anybody. He wasn't doing it daily or weekly. And yet he's painted with the same brush as somebody that may have harmed a child. And I just would like your comment on that.
Well, I certainly agree with your sentiment. And the only thing I might observe is that this isn't going to be all that helpful. It could be worse. Because in California, I mean, this is one of the great frustrations here. When we finally reformed our registry law, which was California the first registry in the country, went back to the late 40s. It was adopted originally by the city of Los Angeles to get all gay men on the registry, and then it morphed into what became the sex offender registry. And we were in the camp there with Florida and South Carolina. We had everybody on the registry for life. There was no path off, or, pretty much no path off. So we had this great reform, and we created tiers. But people whose only offense is looking at CP, someone like your son, is still on life, is in the highest tier, because one particular legislator who was in a position to wield a lot of influence insisted on that, even though it wasn't the recommendation of the official, the California Sex Offender Management Board, et cetera, et cetera. So yeah, I mean, it's absurd. We're going to try to fight that here, but it's very, very difficult. And I have discovered that in my efforts on that front, that that offense in some people seems to trigger a bigger visceral reaction than even some contact offenses. I don't understand it myself. And it's certainly the case that all the data shows that people whose only offense is looking at pictures are among those least likely to reoffend. They have very low reoffense rates. So it really makes no sense. Before I got involved in this the way I am now, when I was still teaching at Arizona, I did get involved in a case of a guy who was prosecuted for CP back in the old days before it was even on the internet. He'd gotten it in the mail. So we're talking about a way back. And they had a law, the Arizona law, and it's still a law, is life in prison, effectively, because it's 10 years, a mandatory minimum sentence of 10 years for each image. And I don't know how they would count a video, but it's got to be more than one. And so, I was trying to help. Yeah, I mean, any event, all I'm saying is this particular offense in some arenas seems to generate a completely disproportionate reaction, even worse than other sex offenses. So any event, I agree with you. You shouldn't be on the registry for 10 years. There should be no public website. But for anybody, certainly, I don't think. The American Law Institute, that's worth noting, has just adopted an amendment to the Model Penal Code. If it were adopted, it basically bans public websites. There are none. And it takes most people off the registry, and the handful of people who've committed the most serious offenses, and it's really a small proportion of all current registrants, they wouldn't be on the registry for more than 10 or at the max 15 years, unless they reoffend. But it would be still only a law enforcement access only registry. Nobody else would have access to it. So
Right.
there are efforts to reform, but it's a kind of one step forward, one step back sometimes, I think. Hopefully we can get it to be 2 steps forward and 1 step back.
Yeah, thank you, Ira, for that wonderful response. Ron and Terry, thank you for that question. We're going to, right now, I'd like to just make a comment. I promise to end our meetings on time, and it's my commitment to you. It is 8:31, and my commitment is to end the meeting at 8:30. So I would like to allow anyone who would like to leave the meeting to go ahead and do so, if you must, and we completely understand. However, I'd like to get maybe 1 or 2 more. There's a few hands raised. I'd like to get 1 or 2, if that's okay with Ira.
Yeah, I can stay for 1 or 2, and then I think
right.
I do have to go, but that's fine.
Thank you, Ira. There's Mark Thompson has had his hand up for quite some time. Mark?
Hi, Dr. Ellman. Sorry, Professor Ellman. Rational words are the tools of civilization. And my father is the offender who is required to register. I'm sorry. And a lot of people are talking to me and will say, they're not talking to me. And they will say, I don't think we should talk. The law is spoken, enough said. My father has Alzheimer's and he's exhibiting sexual disinhibition, which is a common symptom of Alzheimer's. And even the Alzheimer's Association is avoiding, not really engaging with me, despite reaching out to me. And these are all people knowing they have valid points to make. And you just made a number of very valid points too in your paper. I'm wondering, do you have similar people avoiding you, and how does that feel to you? And do you have any advice for me?
Well, I'm not, as I say, the system is struck close to me because there are people I care about who are on the registry, but I'm not. And the fact that I write about this has so far not generated any problems for me. I'm thankful to say I did once, when I first started getting into this and was still an active member of the faculty, there was a project I wanted to do. I can't remember now which project it was. And I tried to get one of the graduate students in psychology with whom I worked, and see if she was interested in being a research assistant on this project. And she thought about it and she came back and said, I don't think I can do that. I think it'd be bad for my career to work on a project like this. And, she might have been right. I don't know. I wouldn't affect me. I was, this is a good reason for tenure, right? I'd been tenured 25, 30 years before I started doing this, and now I'm retired. So it's all irrelevant to me, but I could see, but there are a lot of academics who work in this area now. So it must not be too much of an impediment. And I'm thankful for academic freedom in that regard.
Yeah. Well, thank you, Professor Ellman, for your question and answer period. I have pushed Professor Ellman to his limits and 5 minutes beyond. And so I need to keep my word and allow him to move on to his next event. I would like for us all to give Ira a big, warm thank you for his presentation and being with us here today.
Well, thank you. Thank you for inviting me, and I'm glad I was able to do it. So, bye-bye.
All right. Thank you, Ira. Now we begin Mike's Open, and it's a period where we all have questions or conversations or anything that we might want to get off our chest, talk about, or what have you. There's enough skilled people in this domain that can answer a few questions that you might have. So anyway, who wants to be the first person to make a comment? Eric, you have your hand up.
Yeah, I'm just going to kind of repeat the question I was going to give to Professor Ellman. You know, I'm kind of new to gathering research and study, and recidivism rates confuse me because I've heard, you know, that there's some states that look at any crime as recidivism or any felony crime. I've heard other states will count failure to register crimes as an additional sex crime. And other people, it's only going back to the base crime. I'm confused on that. And I just wonder if there's anybody out there that can kind of clarify that.
Well, I know you're not the only one. I get asked that question a few times, and my understanding is there is no set system from one county to the next. And some reoffenses are failure to register, or any offense that they might have is a reoffense of the registrant. But I don't know the answer to the question. I do know that a lot of people have issues with it. Does anyone have anything for Eric?
Well, I just have to say that there's a lot of debate out there. And, you know, one of the problems with the registry, other than the fact that it exists, is the fact that it's not broken down very well. You can't determine anything about it. And we were told here in Missouri that when we went to tiering, at first everybody was, you know, all registrants were lifetime. Then we went to tiering. And some of the people were told that, you know, that the sheriffs could put them wherever they wanted, which just blew me away. But they're, you know, they're technical violations and they're not reoffenses, but a failure to register is another felony. So to me, they try to get more people on that so that that's another felony and they can keep people employed. That's my opinion.
All right, thanks, Eric. There is another. Amber, you don't have your hand raised, but if you could raise your hand, I sure would like to hear from you. We're going to go to Jim Sevier. Jim Sevier.
Yeah, can you hear me or am I still muted?
You are loud and clear, sir.
All right. First of all, I wanted to comment on Eric there. He was saying he was at the Narsal in Houston and he was the only one there from Missouri. Well, he was incorrect because my wife and I both were there this year. And so I just wanted to tell him, I'm sorry we missed you. I would have enjoyed talking to you, I'm sure. But anyway, going on, I wanted to comment on Professor Ellman there. He was awesome and had a lot of comments that kind of opened my eyes to a couple of things. And so I wondered, he said he was in California or is he in Arizona? I never really was clear on where he's at.
California.
He's in California.
Right.
He lives in Berkeley.
Mm-hmm.
And
Okay.
he has a garage he converted into an office. And that's where he was coming from this evening.
Okay, well, that answered that question. So I guess I'm good then. I would really enjoy the war room, Mike, and I'm appreciate all the guests and everything. So thank you very much.
All right, Jim, look forward to seeing you at the next one.
Okay, I'll be here if I can.
Next, Ed, you've had your hand up for a long time. In fact, that hand just started waving back and forth. I'm trying to get you unmuted. There you go.
Yeah, my arm was getting tired holding it up. Eric, if it's any consolation, Eric, you're not the only one who's confused about that because all the officials are confused about it because the states have different standards. They record different things differently. The feds have their own reporting standards. It all gets jumbled up and nobody really knows what's going on. But you might look at this recent meta study that was just released it's in the Journal of Experimental Criminology. And you can find, I forgot where I found it, is either at FAC or at Axol, I'm not sure which. But it tries to combine all that stuff in a bunch of tables. And, you know, if you're a data freak, then that might be a good place to go. So I might suggest that because I'm really still confused after just scanning it. I haven't really digested it. But Professor Ellman made a comment about how it's just a totally different subject, how they would count videos. The feds have a standard of counting each video as 75 images. So I'm done. Thank you.
There's a guy, a young guy in Arizona that he got adjudicated for all the images and each image. And he got 265 years, I think. A young guy.
Oh, wow.
Mhm.
That's obscene.
Have to have him taxidermied, I guess.
That's obscene. So we have a hand up. Amber, you have I believe your email address is Amber Speaks or
Amber
something
Speaks
like that.
Up, yes. Yep.
And you have a podcast?
I do. Yep. So do you want me to talk about that?
You can talk about anything you want. It's mic's open.
Okay. So for the first thing I want to say is everyone on this call, you are the best because you're taking the step just to be involved and learn and do. And that's step number one. The second thing, we can talk about Amplified Voices. So Amplified Voices is a podcast, and it's there to amplify the voices of people who've been caught up in the legal system. It's not specific to the registry, but we do make it a point to have pretty much every other episode does include somebody who has been impacted by the registry or sexual harm in general. So you can find it anywhere on your preferred podcast player. It's on Apple Podcasts. You can also find it at amplifiedvoices.show online. So I see a couple of the guests that I've interviewed on the call tonight. So I know Marty's on here and Mark is on here. And if I'm missing someone, I'm really sorry. The other thing I just wanted to tag on to are actually two things. In terms of the recidivism rates and the reoffense rates and what you call it, and it's only as good as what's being measured. And I'm going to echo what everyone else said. Nobody measures it the same way. So whether it's the states or the federal government, but the people that measure it are also the people that administer the criminal legal system. So you have to take that into account when you're looking at how they're interpreted, how they're presented, all of those things, because there's a certain framing that goes along with it. Mm-hmm. And the prison policy, they have put out a lot of information about how things have been framed. So I would definitely have people like looking at that. And then the other thing I want to mention, because we did talk about like child pornography and things like that, which is grossly blown out of proportion and disproportionate in terms of the sentencing and all of that. This is all true. But I just want to caution people, especially if you're new to the space, when you're discussing the injustice that you've experienced and your own pain and your own, thoughts on it, is when we use language like so-and-so only did this, or somebody did not do this, you are legitimizing the registry for someone else. So as much as we feel our own pain, there are people out there who are wrongly convicted. The more we talk about it's it's only, the people who are wrongly convicted, or it's only the people who have disproportionate sentences. We inadvertently bolster people's thoughts around the registry. So there's different language that we can use, and that's super important.
All right. Well, I'll tell you what, that was valuable information, Amber.
Thank you. I appreciate you guys having me. This is such a wonderful group of people, wonderful organization, and you guys are doing great work.
Thank you. We have another hand up, Kathleen Garner.
Okay, I'm unmuted. Thank you.
Yes, you are.
I don't know if all of you can see the steam coming out my ears, but I'm sitting here boiling over because I'm furious about the stranglehold the legal industrial complex has on these laws. The reason that CP has become such a horrible, horrible crime, and in California is on tier 3, is that ICAC, Internet Crimes Against Children, has become the cash cow of the legal industrial complex. Thank you, Vicki, for the thumbs up. And everyone is afraid to say so. It was a compromise that got CP on tier 3 here in California. Do you all know that it was a compromise early in this country that made African Americans remain slaves in the South so that the plantation owners, and think of all the important aristocrats in our country who were plantation and slave owners, but it was to further their economic situation. Well, that's exactly what's happening today. And I don't know what we're going to have to do something about this. They're pretty strong, and by golly, they've got all the badges, the weapons, and the money and the power. And I am talking about cops right up to legislators and persons who are in very high offices in this country. And that's really all I have to say. Thank you, Mike, for allowing me to.
Well,
if you want to hear more, call me.
Well, you said you always fill us with such good wisdom, good conversation, and
Thank you.
You inform us every time you speak. Thank you, Kathleen.
My pleasure.
Sherry, hang on. Let me get you unmuted there. There you go.
Hello. How are you guys doing? I was wondering, Amber, if you had some contact information that be okay for anybody to reach out to. I can't hear. She's muted.
Oh,
She's
hang on.
muted,
Let me unmute you.
There
you go.
It's pretty easy to find me, but anybody can email me at amberspeaksup@gmail.com. You can find me at Twitter, on Twitter at amberspeaksup.
You said it, amberspeaksup@gmail.com?
Yep. And you can also find me at Restorative Action Alliance, and that's restorativeactionalliance.org.
Okay. All right. We've had an interesting situation where we are, our son's been on probation for 10 years, or the whole thing has started 10 years also for CP. He 2 years ago was violated with a computer and a smartphone because he wanted to kind of be a little bit normal and, participate in the real world. And he's been on intense probation since, but the interesting thing is that they thought that he should have gotten more time. So probation and treatment have been working together to try to find ways to violate. And the last thing we did was had a staffing finding out that he had lied by omission from 2 years ago, get kicked out of group treatment now. So he's not in treatment, therefore he's going to get rearrested. I just don't believe that. I mean, to me, I'm just like, I'm floored. I'm just don't understand how that could even happen. So
Your son is going to be rearrested?
That's what they're telling him. He's not in group. He was discharged unsuccessfully because he lied from 2 years ago. And he didn't reveal that in his treatment that he did something 2 years ago. So that was lying by omission. And this isn't the first time that I've heard this. I also have another guy that had told me that he's always in trouble for lying by omission. It seems like a golden ticket that you can just not tell them something that you didn't think was important, and all of a sudden that's lying by omission. And I just don't understand that at all. Anyway, so.
Was it lying by omission in a lie detector test, or
no?
Where did that come from?
From treatment, so that he didn't reveal that he texted somebody, friends of his, and asked some sexual question 2 years ago.
Mm-hmm.
And since then they became friends, but he didn't reveal that in group. So just seems a little bit odd to me.
So sounds like what you're saying is he revealed something in some moment of truth.
Right.
And it came back and bit him.
Yes.
Yeah.
And that's why some people refuse treatment, is because, of course you have to say you have, if you had one victim, every time you say you have a victim, from what I understand, it's counted as another victim. So,
but I don't understand the different types of treatment that there are different recovery places all throughout the country that you could maybe choose a different treatment program, because if you're stuck in with probation and treatment, I know they say it works hand in hand and it's great for them, but it's not necessarily the ticket that actually lets somebody actually get the treatment they would need.
Right.
Right. Anyway, so, okay, well, thank you for letting me share.
You're welcome. Always love hearing from you, Sherry. Kathleen Garner, did I forget to put your hand down, or do you have something else?
Yes.
There you go.
Yes, you did.
I forgot to put your hand down.
You just about hear me gurgle when I drink my water.
There you go. I'm sorry. Amber, did you have something else to add? Okay. So right now we have Sherry. Do you have something else to add? Okay.
No.
I'm forgetting to lower the hand, so I can't remember if someone's raising their hand or what. We've got another hand up, and that's Marty. Marty, you are unmuted.
Yeah, Sherry, very, very important. Get an attorney to represent him at the violation hearing. I'll tell you a little story about when I was on probation. I wanted to have certain modifications to my probation, and I asked both my therapist, court-mandated therapist, who was a master of shaming, and also my probation officer at the time, who did not like me, for the modification hearing. Well, what they did was they told me I would have it, that I would have my day in court, and they set me up to go into court. What I did not know was that at the time they created a list of violations, and instead of being a modification hearing, it was going to be a violation hearing, and they gave me the wrong date, 24 hours after the time that I was supposed to be there. I brought my attorney with me when I came in, totally unexpecting all of this. And I walk into the courtroom only to find out there's a bench warrant for my arrest. And it was my attorney who went up there, fought for me, and was able to get the violations dismissed and get the modifications actually approved. So I'm just going to tell you this right now. If you go in without an attorney, he's lost. He's done. It's history. If you go in with a good attorney, there's a good chance that you'll be able to fight this off. So I know it's going to cost a couple of bucks, but my advice is just do it.
Good words, Marty.
Thank you.
Unmuted? Did you have something?
Right. Yeah, no, I appreciate that, Marty. I think that's great. We do have an attorney. I have given him a heads up already. we're not sure if they're going to ask him to self-surrender or if he's going to actually get arrested. We don't really know where we are at that point. So, but yeah, I did alert the attorney already, but I'm just floored by the system. After 10 years looking at this revolving door and looking how they operate and just seeing the different ways that they could approach everything is I just have no words after a while. It becomes pretty crazy.
It's totally understandable. They want us to fail. And, the bottom line is we have to fight no matter, whatever it takes. And, I'm hoping that with the attorney that you guys will get through this okay with no problems.
Yeah, I appreciate that.
All right. Thank you, Marty. Thank you, Sherry. All right. Barbara McClellan, you have your hand up. What say you?
Okay, I have a question here from a family member.
Hey, how are you? My name's Kyle. I'm Barbara's son.
Hi, Kyle.
And hey, I've enjoyed the webcast. It's been very informative. I wanted to shift gears a little bit and talk a little bit about, the possibilities that are out there in terms of taking advantage of what the federal law will give offenders, which is, I'm reviewing cases and I'm actually working with a gentleman now to get declaratory relief from the duty to register under federal law. And there's been 4 cases that I'm aware of gentlemen who have been able to get such relief, and they've been able to take that federal order of declaratory relief. These are all tier 1 offenders. And if you're familiar with the SORNA, the federal tier class, the tier 1 offender is required to register for 15 years, but can be removed from that duty after 10 years if they meet 4 specific criteria. That is completing a treatment program, completing supervised release, not committing another sex offense or another felony. And so while a duty of an offender to register falls within the state that they live in, there is also the duty under federal law that each offender has to abide by. And so my pursuit with a couple of gentlemen that I've been working with is to attempt to go ahead and get relief in federal court. And again, it's been done on 4 separate occasions. And there's another one coming up in Missouri. It's Gore versus United States. This gentleman again filed a civil action after his supervised release term was over. He had served more than 10 years after his release from prison. He was actually going to serve a lifetime of supervised release for child pornography offense. And he was relieved early termination back in October of last year. A month later, he filed the civil suit against the United States for declaratory relief, claiming that he had satisfied his duty as a tier 1 offender. And the court has sided with him. And so he's going to get relief under his federal duty to register. And he's going to take that order to the state of Missouri, which is where he resides. And he's going to attempt to get removal from the state registry. And so I wanted to kind of encourage some offenders that are out there to take a close look at where they fall in the tier classification under federal law and consider whether or not as a tier 1 offender or even a tier 2 offender, a tier 2 offender under SORNA requires you to register for 25 years. But there's been many individuals, obviously, that have committed their offense in the early 90s where SORNA was retroacted back to them, but they have since that time met their 25-year requirement. And so, and since state offenders and federal offenders alike are subject to federal law, this would apply to any offender. So if I was committed of a federal offense, but if you were a state offender and that offense, categorically speaking, is comparable to the tier classification under federal law, this would apply to you as well. I mean, as a state offender, you could go to the district court the specific venue in the state that you reside in the district court, file a civil suit, name the United States as these other gentlemen have as the party that you're opposing, and request declaratory relief from your federal duty to register. And by law, they're required to give you that relief. I mean, it says, it's pretty plain language. So I'd like to see a little bit more of a concerted effort of offenders that qualify to pursue this avenue. It's great that we're talking about trying to overcome and defeat the registry as it stands now, but try to take what you can get, what the law gives you out there, and see if you can just be removed and play the game as they're giving it to you. So I don't know if there's any comments about that out there. I'd be more than willing to, field any questions about it, but I just wanted to bring that up.
I agree completely. You can get your relief and move toward the things that are available now and continue the fight.
Right.
All at the same time. The one thing I would like to mention, if you don't mind, on your talk, which was very informative, is we have a moratorium as the registered nation on the word offender. And we're trying our best to get everyone to take the word and just toss it and not use the word anymore, because no other charge are offenders. I mean, you had a DUI. Well, you had a DUI. You're not an offender. But these charges, you're always offender for life. So we want to use our language to set the record straight. So we're using the terms a registered citizen, a registrant, a registered person, or something like that. So, and since you're vocal about it, I would just like to let you know and see if we can get your help on that.
Yeah.
And I might interject here too. I mentioned earlier that I'm an affiliate member of APSA, which stands for Association for the Treatment of Sexual Offenders. And I've participated in a couple of their group calls because they're trying to rename their organization. And in so doing, they hopefully will remove the word offender and registrant. And for example, you mentioned with the DUI, someone with the DUI, we know a federal judge with a DUI, but he's not a registered drunk.
Yeah.
My point, I'm not trying to trivialize, but I'm also making a point, my point anyhow. So you're right. How the language is used is very meaningful and labeling. I'm in education, and one of the things as a school administrator and as a teacher, I readily knew that when you label a child that falls under a certain classification, that brings damaging effects. And we were continually trying to reevaluate, how that label would or would not be used. So yes, this is a worthy position that's being taken right now to remove the word offender from our language.
And it's Barbara, if I can, interject here too, but this all came about, our moratorium came about after we learned of the American Psychological Association paper, why call somebody what you don't want them to be, and then, and those type things. So we have notified, we've sent out press releases and everything, and we will continue to do that for several more months. Okay, so and when I talk to people on the support line, and I don't know if Kim is still on here or not, but I kind of stop people and say, you're not a sex offender, or your loved one's not a sex offender. They're a citizen required to register or something, and they say thank you for that. But anyway, and also, Barbara, I met your son. Hi.
I know. I just reminded him that he's been hugged by you.
Yeah.
You remember that?
Yeah. Oh yeah. Yeah. I thought that was him in the background
too.
Yeah. But anyway, and to go along with what he said, there's three, I didn't know about the lawsuit he talked about in Missouri. So if you could send me something about a little bit more about what you're talking about. But there's 3 lawsuits in Missouri. There's a federal lawsuit that was filed by Randy Cannon, and there's 40 something litigants. It was filed at the federal level, and it was done that way on purpose. And they're even going to bring Mr. Longo in to testify about his debacle. But anyway, so that's the one federal. There's an attorney here that has 2 state lawsuits. And one is against the registry as a whole. I don't have the numbers on it because I just learned from him the other day that they exist. And the other one is specific to ankle bracelets, because he was the one that got some ankle bracelets taken off of some people that were not mandated to wear them as part of the judge's order. And he got a temporary injunction, which became a permanent because the AG didn't fight it. But now he's trying to get that whole thing removed. So there's 3 here that I'm aware of. Just wanted to point that out.
Well, folks, you guys are 6 minutes into my beer time.
Beer?
My beer time. So we do have a hand raised, and Dave, I will let you encroach a little further into my beer time. Let me unmute you.
Okay, thank you. I know talking about offenders and TDC here in the state of Texas, our ID tags have offender in big red letters. So that they remind you every single day. And for the ankle monitor,
I'm coming.
I've been arrested before for tampering with my monitor. Now, my parole officer didn't care, but she said I was tampering with my monitor, but I didn't. And I spent 35 days in the Travis County Jail anyway. And as far as Missouri is concerned, just to give especially Vicki an idea, my roommate has been trying to get an interstate compact from Texas to Missouri for 20 months, 1 year and 8 months. And he's been shot down about 5 or 6 times. So that's just another, to me, it's just retaliation. But that's all I have. Now it's beer time.
Yeah, well, I'll tell you, without someone on the other end accepting the transfer, it won't happen. I was so lucky to get my transfer from the revolving doors of California, because my brother-in-law was a deputy sheriff here for 25 years. And he actually was in the court working with all the judges as a bailiff, as a court deputy. And he had the keys to all the judges' chambers, and it was real easy process for me. I was just lucky.
You're lucky.
Yeah,
very lucky.
David, is that a state or a federal interstate that he's trying to get, or what is he?
It's state.
Okay. And if you can send me something, about that, and I'm not going to be able to affect it, but I'd just like to know about it.
Sure. Okay. I'll send something to you, Vicki.
And I'm putting my email address down here. Go ahead.
Oh, good. Okay. Yes. Thank you.
All right, Mike's open is about to close, but I really would like to hear some words of wisdom from Richard Gladden before we take off. Do you have any closing words before I say goodbye, Richard?
Well, first of all, I've enjoyed being on the show tonight and listening to all the other comments. It's always, I'm an attorney, and so I do hear a lot of stories in my line of work, but it's always interesting to go on shows like this or programs where I can hear other people from different angles than being necessarily family member stories. I like a lot because of course, we all realize that people who are required to register, it doesn't just affect them, it affects their children and spouses and family members. I don't have too much to add. I often tell my clients that although the state laws that they're having to survive under are very harsh, that there is always opportunity. And I think the trend is moving our way, that over time, eventually, state legislators are going to realize that what they're doing is causing more harm than good. and we can reform these laws. Of course, it's kind of a multi-pronged effort, as you've got the judicial system by filing and engaging in litigation, but it's also important to be involved with your legislators. In Texas, Mary Sue Molnar's done a fabulous job. Is that we usually have a couple of dozen people during the legislative session, either fighting bills that are totally absurd or even getting legislation passed. At the beginning of this broadcast, we talked a little bit about taking someone's employer's name off the registry. That's one example of things that can be done, but it's only one. Obviously, taking an employer's name off the registry creates a lot more job opportunities for people who are registrants looking for work, because it's kind of a brick wall if your employer knows that their name is going to go up on the registry along with a prospective employer. But I could probably go on forever. I've recognized a few faces. It's good to see Vicky. It's good to see Amber again, people I'm already acquainted with. And y'all keep up the good work, and I hope to come back. Do y'all have a particular day of the month that y'all have these things?
Yes, sir. We have them the 2nd and 4th Tuesday every month.
Okay, I may get a hold of Vicky, or who do I need to get a hold of to get some kind of alerts on these things?
We'll set you up with that.
Get on Vicky's list.
Okay, that sounds
A
great.
good list.
All right, well, y'all have a good week, and that's it for me.
All right, thank you, Richard. And in closing, I just want to thank all of you for participating in the War Room. I look forward to the War Room all week long, every day. I think about the next show, the next presentation. And for those of you who are new to this environment, you've just got sucked in to this horrible whirlwind, you're not alone. There's millions and millions. If you notice, there's a lot of mothers, a lot of fathers, a lot of brothers. The collateral damages caused to loved ones are multiplied the amount of people on the registry. And keep coming back here, 2nd and 4th Tuesday of every month. Participate, find your voice, develop the courage to stand and speak. Once we figure out we are not alone, the fear starts leaving our system, and we slowly start developing a bit of courage. Whenever we figure out we're not alone and there's others, millions and millions of us, and once we start marching to the same drum, we can affect positive change. I will tell you, millions of votes will turn a tide. It most certainly will. Just keep coming back. Thank you guys for being a part of the War Room again, and have a good night.